My lord may allow, my learned brother has no objection. Today itself, if I may be allowed, sometime I'll go through this.
At 2, my at 2. At 2. My pursuant to my lord, my learned council's my lord, request at 2.
Obviously, he is requesting, not by you.
May I please the lordship? The poetry application lordship, the accused he was arrested on 14/4/24. The NDPS case 21B 22C. I have no last date he was there. On the last occasion, I was not there. He took time, but CD was there, according to him. On the last occasion, on 3 तारीख इसने last PS case to hold Gauripur PS case number no 11124.
In fact, it was received. You have
Now
not the
I
case diary with you
I don't have now, Lordship.
because the order was there.
No, that's why. That's I was not there.
The order to retain the case diary
That was there. That's why
because adjournment was freed.
I was not there.
So you just make an
And
inquiry.
let them verify.
Yes, somebody.
of this.
Gauripur 111/24. 111.
Okay, I will.
So at 2 your lordship will kindly speak.
Some other works, in fact, for continuer. Let him inquire the matter.
No.
We'll sit for some time. We'll
Lordship.
attend. If it's already there, then we'll peruse.
Lordship.
Time.
May I please your lordship?
Yes.
The petitioners were arrested on 1st of August. Today is 47 days behind the bar.
Huh.
FIR is placed 11 months. One SI of police filed this FIR stating that they were in Nagasaki. In the meantime, some traffic jam was there, and the present petitioner and some others obstruct to conduct that Nagasaki, and also alleged here that they have taken the pistol from them and tried to attack them. These are all allegations against them. The fact is that the present petitioner, they have no vehicle. Their residence is near the place where the Nagasaki was conducting, and the informant was taking the fine from the person who violated the not wear the helmet and some document was not proper, but receipt was not given. So the people, a large number of people gathered there and forced that police, whether you have taken the fine, you issue the receipt, otherwise you will be separated. And there was some person video footage also taken by the people against that policeman, and they also informed that informant that we are going to file complaint to the higher authority against your activity, in which you are collecting huge number of money without giving any receipt. And this there was a altercation, a debate, no physically any assault or nothing there. But thankfully, the informant only to save their team, file this affair. It's a concocted affair, Otherwise, the present petitioner, they are nearby resident of that incident, So very unfortunate. They have no vehicle also. They come there and only the informant came to learn their name from some important person, because maximum person was from other place. It was not a clue to find out their name. Only there the nearby resident, their name somehow collected and filed this FIR, So 47 days behind the bar, So maybe consider, and police also did not take them the custody also, for further interrogation,
Yes, sir.
Lordship, first I want to state what you have argued, Lordship. You don't have the bike also, Lordship. You are stating that some people are wearing helmet or like this. Lordship. He has no business to stop this person. he before coming to the Nakasiking Lordship, 100 meters beyond Lordship, he stopped the vehicle so that they could not come. And when these police officials go to that place and try to remove these obstacles, Lordship, they have created Lordship. At that point, they assaulted this person. So if I look into this Lordship, the other witnesses, this Atwar Rahman, he has snatched this Lordship, the arm, service pistol. And moreover, this other person, they are obstructing the person's Lordship. They were in way, 353 is there, they are obstructing the government officials, Lordship, to do their duty. So it is attracted, Lordship. So I have objection on that point, Lordship.
The story, my lord, whatever prepared by the informant, very unfortunate. Otherwise, the people, what is the interest, my lord? And what is the ground, my lord? Why they will obstruct the police, my lord? Because every person,
Petitioners,
yeah,
they who filed petition,
No.
are one Asad Ali and one Amir Khan.
Lordship.
Akbar, the person who snatched the
it's-
pistol,
It is not before us, Lordship.
he is not before us.
Lordship.
It's haven't taken.
Lordship.
Sufficient maybe for interrogation.
what is
Otherwise, any other materials are
Not
there, then it's okay.
But incriminating materials are there, Lordship, in city.
I'll record your submission.
Look.
And then we'll run it on the petition. And also heard Mr. K.K. run it in application for section 6, connection with so they did the same part. It is submitted by the state council for the petition. All the concocted allegations are brought against the defendant. In fact, they do not have any weight. But on the spot, but on the day of the incident, at the time of narcotic, the police personnel is fined from the persons who violated
SDGM not so
who violated the
Oh,
But
essential section
they
of
do not issue any.
It is- it is there.
It is not. Some of the persons got breached and there was a situation where some quarrel between some of the local persons and the police person. But as they belong to the local group, the name of these persons were mentioned in the FIR. Some name of some persons are mentioned in the FIR and accused, out of which the name of these two petitioners, deputy petitioners' name are also in the FIR. Mr. Udit further submitted that the accused with the petitioners are released to 47 and that the I was this time for their investigation. Further custody information may not be necessary for the investigation. However, the petitioners are really and property I important participants if they are allowed to go on there. Mr. Das is managed that there are sufficient preventive methods against the petitioner, including items. Rather, they obstructed the objectivity of the police personnel who were busy in narco-seeking of the vehicle. These petitioners, along with others, restrained some of the people from not to come from 100 meters of the second point. And one of the co-accused was used as the pistol of the police person, and thus they obstructed the police person and also tried to and also assaulted the police person who were on the scene. Accordingly, he raised objection in granting bail to the police person. After hearing submitted with mediation of the witnesses, I have built the district with dialogue It is a full stop. The fact that there are sufficient materials against the present accused petitioners along with the other two accused persons. But it seems that one Anwar Rahman uh, wa- was basically involved in this case, who also snatched a pistol from the person. However, do not going by the merit of the case, considering the length of detention already undergone by the petitioner, I find that further custody interrogation may not be necessary for the purpose of investigation. Where from which case is from?
Well, additional district and session judge, North Salmora, Abhaypuri, page 13, forwarding report.
Why additional district?
Well,
It is started one.
Not succeeded, my lord, but I am also thinking, my lord, it should be SDGM, North Salmora, Abhaypuri. But in forwarding report, my lord, one section is Arms Act. Even then, before such sheet, my lord, may not be produced before the additional session judge. So, my lord, the learned concern Alaka magistrate may be mentioned, my lord. It will be better, my lord.
Armed Act is there, but
E-
that
e-
will not bar from any.
Okay.
Unless it is under any
Ye-
special act.
yes.
Suppose
One
NDPS or
special is that
so-
prevention of damage of to
Even-
property.
Even then,
That is also
yes, my lord.
Lordship, come, Lordship.
So, Alaka magistrate may be mentioned, my lord.
Elaka mein.
the satisfaction of the Ilaka magistrate. Okay, will
I am obliged, man.
20,000. I think. না, আপনি মার্ক করে দিছে তুই ইয়াতে। হুম? অ। 23 আছে নেকি? নাই। ও আছে।
This
Yes.
is 482 application, my lord,
Ah.
with a prayer for quashing the FIR. Can we come to page 15, the relevant portion of the FIR, my lord? This honorable court had earlier stayed the investigation. The allegation, page
Similar
15 is,
matter is with court number 20,
That's
14
what I'm
Lordship.
saying,
So
we can do one thing, otherwise matter may be admitted for hearing.
Lordship, that will be there.
Otherwise, they may
Lord.
not be prepared. In fact, we are looking after the cases from the other court.
And we don't have the files also, Lordship. It is, as it is also 21 and with item number 21 with 22. Oh, no, Lordship,
it's
sorry,
not.
sorry. No, sorry.
21 with 20.
No, Lordship, no, I'm sorry. It is with, 22 is there. But let it be admitted, Lord.
No, I'm not.
21 is singly there. Lord.
Oh,
not
yes,
with-
22 is single.
Single. I'm sorry.
So, do you have any to say in the matter of admission, or it can be listed after?
Let
Then
it be
generally
admitted,
what
Lordship.
happen, I'm just going. In a criminal petition, it's like in admission matter itself, it can be disposed of. So if it comes in the hearing list, then it may not reach also. That's why. That's why I'm saying let it be on the admission column itself,
Yeah, then
or what to do.
on 29th of October, my lord, after Puja vacation.
29th of October, after Puja.
And this time I kindly be confused. There is an interim order passed by this honorable court,
Interim order is there.
my lord. Otherwise, the matter is very simple, my lord. Allegation against me is that while I was a minor, I forged my birth certificate and I have shown so and so as my mother, whereas my mother by that time had not married my father. That is the allegation, the basic allegation.
Hmm. But
Fortunate
you
or
are minor at
unfortunate,
the time.
fortunate or unfortunate, my father had married 4. Now, so far myself is concerned, I always knew this lady as my mother. And I was only 6 months old when this birth certificate originated, my lord. Now, whether any imputation can be made against me of forgery, my lord, and I have always treated as my mother. And every other document, my lord, apart from my educational credentials, every document, be it Aadhaar, PAN card, passport, every document was issued while I was minor. So apparently there cannot be any allegation against me. And always the parents go to the hospital authority for any sort of registration, my lord, not the baby herself.
Okay, we are listing it on 29. Maintain Kadika.
Obliged.
Assisted by Mr. Also hardware. The request that listed matter 29.
Meet the order. 482 application, my lord.
Yes.
A challenge and attachment order made by the IO under section 1111 of the Cattle Preservation Act. Limited issue involved, my lord.
Before hearing you, yes, Ms. Begum.
Lordship, let this data be fixed because there are with 5 files we have not gone through, Lordship, because
We are facing
due
that.
to the
In the
Next,
yesterday night, in fact, that situation had
in the
happened.
morning the list was there. Lordship.
So in the night also,
my lord.
the arrangement could not be made because Chief Justice says in
My
fact he is out of station. That is why we are not today hearing. So
Next
let's-
week, my lord, any date, my lord?
Next week.
Next week?
Next week. You want any date fixed or
My lord may fix a date, my lord.
should not? After 1 week it should be, I think.
It will be very difficult for getting it listed because of the vacations, my lord. So if the date is fixed.
By the way,
30th. 30. 30th of September.
Can it be on 25, 26, 27?
Right. Court is to deliver court is done on time. 25, 26.
Or 27?
27.
27.
Highly honest.
Kurang mahal. Takut. 20.
সম্পন্ন
Timing কইছো? One from the center. $51. Yes.
Lordship, can you this matter may pass off for timing, Lordship? Argun Council is late on court number another court, Lordship.
pending.
Can you,
Why it is in order column?
Lordship?
Can you tell us?
IS.
Ayo.
I is there.
IS there, Lordship.
No, I is not there. There are some
51.
services available. No other
Service center one of it. Ayo.
clinic.
14 or
Someone had filed Bakalatnama for respond number 2, in fact. Who is appearing? Do you know?
Lordship, we have taking a step for Iowa. On the last order, the
IO?
service is not complete, Lordship.
not complete.
Not complete.
No. Respond number 2 is representing by someone who is
A.N. Ahmed.
A. Mehmet. A.N. Ahmed. Huh?
No, I don't 14 no. Court number 14.
Whatever matricular amount is any other submission from your side?
Lordship, kindly matter may be taken up at 2, Your Lordship.
Who I cannot
Oh, এটা ডেট লইলো
Kindly, Your Lordship, kindly another date may be given, Your Lordship.
Otherwise, it was in order column, in fact. If you are ready, then we can pass the order. You can just go to the request made by students. Is the matter?
14 হয়
After one.
এটা দেখে বলতে হয় দিন হয়
আমার সঞ্জয় দাস আছিলে
হয়
হয়,
সঞ্জয় দাস
সঞ্জয়
হয়,
দাস,
হয়। তো 14 হয় এদিকে কোড নাম্বার সঞ্জয় দাস
কেউ নাকি বারে বারে আপনি কেউ কোড নাম্বার 14 বিট একবার কবি দাও তো কোডটা কোডটা করো কোড নাম্বার 14 বিট কই
Yes. May I please your lordship. Lordship, in this case, step has been taken, lordship, but the answer notice or ID card has not been returned, and the scan copy was also called for, and the same has not been as per perusal of the office notice.
52 খন আহি গৈছে রেসপন্ডেন্টৰ কাৰণে
then you want
he
to
is
wait.
not present respond receive Lordship because
No, no, respondent 2 and 3.
2 and 3 yeah
For respondent 1, we have taken step.
1
She respondent
1 কোন স্টেট কোম্পানি
private
স্টেট
step 9.
স্টেট নাই
For one, it is waiting, I think.
oh state
Yes.
নাই oh Lordship state is not
State is not here because the matter for it is for DV case, lordship. An order we have been challenged before this honorable court.
Do you want to await or you want to take steps? Because notice and ID card are not yet received, I think, as per office note.
Already we have taken steps, lordship, because
Can it
again we will take steps in the same address only because the respondent number 1 is residing there.
You are Mr.
PK Basu on behalf of A Biswas.
Part of the ticket of appearing on behalf of Mr. A. Response, Council for the Petition. An application call for the response number 2 and 3. So, names of two learned council have been reflected in the call list. From the office note dated 6/9/2024, it reveals that the notice issued on response number 1 is still waiting. Neither ID card nor answer notice has been received back at the second. Further, it is seen that even after issuance of the reminder, the answer has not yet been received. Issue first reminder, registry will be immediately. Await for service on response number 1. Is the matter according? Code number 14. So, I follow up with you. I am going to look at timing going to solve.
Your Honor, senior counsel is another court. Kindly pass for time being, Your Lordship.
Now we are passing over lost many matters for time being. I do not know.
for a day then Lord
Pardon?
adjourn for a day because it will
You are not in a position.
no Lordship because no files are with us
Actually, just I want to say, we are having some problem from the prosecution side. I think. Because files are not with them. It is suddenly it is arranged suddenly, na. So better to adjourn this one because otherwise they are not in a position to submit anything.
Your Lordship, it is-
Prosecution side is not in a position to submit anything because they do not have the files. If this arrangement is, in fact, in the morning itself, if the arrangement has been made. So let the matter be listed after 1 week.
next week, Your Lordship.
Yes, that's
1
what we're
week.
saying after 1 week.
Fix a date, Your Lordship. Mama. Next week, fix a date, Your Lordship.
The
After,
matter
before
of
looks.
24, how can I fix a date?
no after 1 week Lord.
Oh, after 1 week.
after
It's not listed after 1.
Yes.
It's there only. This is the matter after when as the learned citizens will be MS category is not in a position to argue the matter because of non-ability to advise. Just after 1 week. Okay, it will be listed after 1 week.
One year.
5 years.
5 years.
May it please, my lord. The appellant preferred the judgment and against order dated 7/8/2024, my lord. Punishment is, my lord, 5 years, my lord. Both the appellant, my lord. Page 50, my lord. Section under section 366A and 34. Initially, my lord, in POCSO case registered, and this villain, my lord, was convicted for 5 years, my lord, under section 366A and 34. Case 50, my lord.
Review with earlier it was POCSO lordship. So, oh, yeah, Indiana. अच्छा. हम POCSO থেকে ইনফরমেশন নোটিস দিতে লাগবে তো এখানে.
And it will take appeal memo. Jail it. No matter. Jail to no matter.
Lordship, as I is there, Lordship, elsewhere
Yes,
will be
ma'am.
required, Lordship. Criminal appeal, Lordship.
No, it's okay, but though it was earlier mostly registered as POCSO, that's up to the
Yes, my lord. One, my lord, one
Three
accused was
accused were
convicted,
there,
my lord. There is
One.
3 accused, my lord. Case 49, para 53. There is another accused, my lord. He is not here, my lord. Not before your honorable.
For that, Lordship, elsewhere will be required, Lordship.
three accused persons are already convicted.
Three, my lord, convicted, my lord. One, my lord, Biswajit Dole. He is under section POCSO also convicted, my lord. And my lord, here, my lord, Marge Kuli and Laban Pegu, they are convicted under section 366A of 34, my lord. They are in your honorable court, my lord.
But your appeal memo does not say so. Why it should be matter should be clarified.
Yes.
The conviction was passed against so and so, and this appellant against so and so. Simply you have said that this one is convicted under section 366. Why? The case of POCSO only.
Yes, my
He
lord.
may not be convicted under POCSO.
In post title, my lord, page 2, my lord, I have mentioned, my lord.
What you have mentioned.
Yes, my lord. The accused appellant to under rigorous imprisonment 5 years each to fine pay 5,000 only each for committing the offence punishable under section 366.
That's what I'm saying. As if you are presenting the case as if it is a case of under section 366 by 34. Why?
Yeah.
The other one accused, other one
Yes, madam.
He has
Otherwise,
already been convicted under section 4 POCSO.
yes, madam.
So you should clarify this point that the section 4 was there, but your petitioner your applicant may not be convicted. That is different thing.
Yes.
But otherwise, case is of POCSO 4 POCSO.
Yes, case is also,
So
madam.
you are just presenting the appeal as if it is a memo of appeal, as if it is a case of 366.
Yes, my conviction, our conviction is.
Your conviction may be.
Yes,
It's
madam.
366.
Yes, madam. Also, madam.
But you should disclose these things now here. Who is Srimati Palapati?
Palapati, my lord. Informant, my lord.
You should notice that.
Yes, ma'am.
And also call for the health. To respond number 2 through 8 as per the compliance, a co-petitioner. The jurisdictional police station routed to the office of the registry as well as public. It will be through jurisdictional police routed through the office of the public prosecutor and the registry.
As a
Yes.
same procedure for
Same procedure. This stuff.
In IA also, my lord, notice.
Yes, I also you can notice.
Obliged.
We are also calling for the LCR so that they can give the their objection.
May I please? My lord, I am appealing for respondent of health. Today I will file affidavit in opposition. Already
You are appealing for the respondent.
respondent of health.
Respondent number 5.
Lordship, I received the affidavit filed by the respondent number 6, Lordship.
6 is already filed.
6 is already filed, Lordship.
On the last occasion, that is on 4/5/2000.
4, 5, and 6, Lordship.
4/5/2024, respond number 4, 5, and 6. Take time for filing their affidavit in opposition.
Lordship.
So out of that, they have received the 6.
6, Lordship.
You are representing 5. What about 4? Any idea?
One.
Lordship, the state also have not filed their affidavit yet, Lordship.
You are Mr. S.
B. Chakma, Lordship.
Hard Mr. P. Chakma, candidate counsel for the petition. Also hard Mr. You are Mr. P. Das.
Clearly, on behalf of Peters.
He is appearing on behalf of Mr. P. Das for respond number 5. It is submitted. How many times a week do you need?
Well, today I will file already.
Oh, today only. Okay. And it is submitted that the affidavit in opposition on behalf of the respondent number 5 will be submitted today. However, from the office note, please note in that respondent number 5 has not yet filed their affidavit. So, the respondent number 6 has already filed their affidavit in opposition, which has already been received by the other side. Let the matter be listed according. After vacation, we'll do
After vacation, Lordship.
this after vacation.
Lordship, if the state respondent, they are going to file their affidavit, Lordship, let
He
them,
is going to file today.
No.
Approximately, sir.
state, Lordship.
Oh, state.
earlier date state was to file affidavit.
Affidavit.
Earlier date,
Yes.
last previous
State is respondent number-
Yes.
State is respondent number.
One, Lordship.
State has already filed, not yet.
Not yet, Lordship. If they wanted,
We are
if they
not
desire to file,
Say
Lordship.
anything now. They're not dealing with the case now, so
Lordship.
difficulty in our part. Actually, she is also not in a position.
Yes,
to
because
better
Lordship,
affidavit.
this is the pricing of my pension account, service account, and my daughter account, Lordship.
Okay.
And I'm facing lots of difficulty now, Lordship.
Okay.
Besides, I'm paying my monthly EMI also, Lordship. All my hands are tight, Lordship.
All the remedy respondents, all the remedy respondents are hereby directed to file their affidavit on position. I have made a direction.
Lordship,
including the
yes.
state also. State
Yes,
will also
Lordship.
give. that.
If they desire, Lordship, yes.
Yes, if they did. If they did.
Humbly obliged, Lordship.
Obliged.
After
May it please your lordship. Lordship, your service is awaited in respect for respondent number 2.
services
Service is awaited.
number 2.
We've taken steps twice, but report has not been received.
Twice in which manner?
My lord, through PP, my lord. Through PP, my lord. It's there in the record, my lord.
Can you tell us,
Okay.
Ms. Begum, and
I will get the information. Look. I will inquire into it. He was a police station.
Police station to अपना मोइराबाड़ी police station. There's an interim order, my lord. So matter may come up after vacation, my lord. In the meantime, they can.
Maybe they have received the instruction lordship. Those who are engaged in 18 lordship, code number 18, as looking the file, maybe they have received the instruction. I'll inquire for them. What Tarpa could you know? And Pabo can get instruction.
so we'll pass the order then.
Lordship may fix a date in
will
the
make an inquiry and report the court accordingly. Otherwise, was there any interim?
There's an interim order, my lord.
What kind of interim was there?
Stay is there, my lord.
Stay was there.
So this is a case where case under POCSO, victim did not incriminate the accused of POCSO. Case went on at the stage of argument. First, the prosecutor comes and files a petition under 311 for recalling the victim. No reasons were cited. That petition was allowed. We challenged it. That order was set aside. Liberty was given to the prosecution that since you did not give any reasons, and that is why it was set aside, you are at liberty to file a fresh application, but you have to give proper reasons. This time the prosecution filed another 311 application. The reason given was to declare the witness hostile. And my lord, the witness had already been examined twice. Examined, cross-examined, again re-examined. So twice examined, twice re-examined, my lord. Then again they filed a petition for
What they were doing at that time?
my lord, they wanted to declare the witness hostile. So we challenged that order.
There's a reason for
That is why it has been stated.
with Mr. Nawal and other constitution, but an escaping with an additional appearing on the top of state. It is submitted by Mr. Nawal that the service is still awaited for the response number 2. In that context, if MSA becomes submitted, then make an inquiry in regards to service of notice on response number 2. Accordingly, after the accordingly people make an inquiry and will inform the court on the next date of till next date of the stay. The order was
4624, my lord.
4624. Okay, we are listing it after vacation. It will do
After vacation, my lord.
After vacation, your stay will be continued, and in the meantime, next week,
My lord.
you will make an inquiry regarding the service.
I'm deeply obliged, my lord.
So, what to do? Oh, it mark for nine. My two 53. Please not. It's a covered mathematics word. 18, code number 18 is finished. Code number now.
Yes, it's not 21 to start.
May I please the lordship? Lordship, report was called for with regard to the freeze account of the petitioner. Freeze bank account of the petitioner.
Report call.
Yes, ma'am. File.
Item number 26.
Yes, ma'am. Okay, ma'am. Oh, this is the lord.
21 business. My report is for what reason?
Freeze account of the petitioner.
Please.
Two orders were there. One was the up-to-date status of the police case. What was the number of the police case? Jalukbari PS?
Lordship, Jalukbari PS case
25.
number.
25 or 24.
Yes, Lordship. 25 of 24.
So one was there, the status report of the case. Another one regarding the freezed account. No?
Lordship.
Okay, freezed account. Now, his records are not available. In fact, Mr. Busho was there. I think. Yes. Jalukbari PS 25 of 24.
Matter, my lord, we have sent the letter to the OC concern. Even I myself also communicate the same. Let we take maybe given some time, maybe office may receive the same.
Lordship, may I please the Lordship? Lordship, there is a specific direct order as per the last order, Lordship. That our case may be, our payment might be considered, shall be considered if there is no, if they fail to produce a report.
What may be considered?
Lordship, our payment shall be considered as per the last order.
Now, see, we are not in a position now.
Lordship.
We
My
don't,
lord, I
we
think
don't
on
have
the
any
last
homework.
petition 3/9/2024. It is the order, last order was
First order I'm seeing.
3/9.
Yes,
Two
Lordship.
orders were there. One is there, the status report of the police
Yes,
case,
my lord, and
and the other
account
one
that
regarding
freeze.
freeze account.
Please, yes, my lord. My lord, maybe I get an instruction from the office because it was communicated by me on 5th of September 2024 to the OC concern. Maybe it may be received, but I am not receiving the same. Maybe office may receive. I'll take a telephonic instruction from the office.
Okay, for timing.
Yes,
Lordship,
yes.
Lordship.
My lord.
Keep your legs.
This is the court number 21. আচ্ছা এইটো টাইমিং কৰিব লাগিব উপায়টো নাই Seven. You are representing the respondent.
Respondent to my two.
Commissioner is the there. Sorry. Timing করিনে dispose মানে order করি an application call for the hard Mr. KK Das on number 1 and you are Mr. B. Hazarika for the response number 2. It was on admission stage, na? Oh. Okay, then we are listing or we're fixing a date. Otherwise, fixing, I mean, next week it will be fixed. Was there any interim and all?
No.
From your side, it will be not be there from petitioner. They are not in a position to say anything or record it looks. Nice.
It's really good.
Stay was not there. Stay is not there. List after one. Stay is not there. We are listing after one. An application call for the lead as the respondent side. This is matter according after. Court number. It was, but it was notified. I think.
Notified.
In which case? According to 45, 21, 45. None application. Yes, after two. After two. After 2 weeks. 46 was any. 46. Oh, thick.
Yes, correction.
46 you are
46, my lord.
Ah.
My lord, two IAs there, my lord. IA 405 public 2024 may taken first, my lord. It's my lord for correction, my lord. For correction in the cost title.
correction. Who passed the order? In fact,
Correction in the petition, my lord. Not in order, my lord. Correction in the appeal memo, my lord.
petition.
Lordship, my lord. There was some typographical error in the cost title along with my lord in the prayer portion, my lord.
By hand করে দিছে। By hand. So what is the correction you say?
Page 4, my lord, my prayer, my lord.
Yes.
Special case number, my lord, incorrectly mentioned as my lord 06, my lord. It should be my lord 47 of 2023, my lord.
Achha.
And accordingly, my lord, in the paragraph,
It's the cost title of the.
cost title, paragraph, and my lord, in the my lord body also, my lord, same mistake has taken place, my lord.
But in body also same.
Because
same.
referring in the case number, my lord, since in the cost title, my lord, it was appearing as 6, my lord. So, my lord, in the body also, my lord, it was appearing as 6. My lord. Everything will be, my lord, in the prayer of the my in this case, my lord, I am categorically mentioned, my lord.
First petition here, if you're saying that an application for allowing the applicant to do correction by hand.
Lordship, my lord.
Hand is not there now.
Then, my lord, registry may, my lord, correct, my lord. I can.
No, registry will not correct. You have to file the corrected or it is amended, whatever copy. This is the now present after the notification.
Right,
This is
madam.
by hand, it is not allowing. In fact. You
By,
can approach the registry if there is anything, any scope is there. I don't know.
if your lordship allows,
I'm not also talking that a 06 can be made 047 by hand also. But it's not here now.
lordship, for that, my lord, order is required, my lord. Earlier, my lord, with the permission of court, my lord, without any application for correction, my lord, it can be, my lord, rectified, my lord.
No, order will be the required. That is the one thing. Another thing is that you have to keep the not by the handwritten. Any correction cannot be made by your hand.
Lordship, my lord, then registry can,
Registry will not. You have to file the entire cost title or whatever title, the entire matter in fresh. Or you can talk with the registry. If it is allowed by the registry, then it's okay. We'll pass the order.
Lordship,
Your petition will be allowed,
Lordship,
but not by hand.
Lordship, I'll pursue the registry.
Heard Mr. K. Purva, the learned counsel for the petition, and also appellant, sorry, and also heard Mr. K. Das, the learned additional PP, appearing on behalf of the respondent. This is an application for correction of typographical error appearing in the memo appeal as well as in the body of appeal, wherein the number of the case number is written inadvertently, wherein there was an inadvertent error in typing the case number. Typed in the case number which is mentioned as 06 of 2023 instead of the correct number of POCSO case number 47 of 2020. Accordingly, the present petition has been filed for correction of the POCSO case number as 47 2023 instead of incorrect number which is POCSO case number 06 of 2020. Prayer allowed in Mr. Das is no objection in this regard. Prayer allowed accordingly. The appellant will accordingly file the corrected amended cost title along with the appeal memo. Appeal memo to stop. This could be the matter according to after. It will be listed after vacation. We don't have time. After vacation, 2 weeks can be given, but 2 weeks, I don't know, 2 weeks will be any day.
Otherwise, 1 week may not sufficient.
1 week. List after 1 week. Listed after 1 week, you made correction.
Lordship, may I prefer a date, my lord, because I am in jail, my lord.
May I pay for a date, my lord? Otherwise, it may not be listed, my lord.
Date to I cannot.
For orders, my lord, because my application for
Since when he is in jail?
since last 1.5 years, my lord.
Okay. The conviction term was
Section 10 of POCSO, my lord.
section 10 POCSO.
Punishable. It was, my lord, convicted by 5 years, my lord.
You press the IA, the other IA subsequently. A date cannot be, it can be given.
Next week, my lord.
Next week too, it cannot be.
At least I can take a chance, my lord, before vacation, my lord.
First of October. No other.
1st of October. 1st of October, without short. Oblige me.
You want photo?
It's a transfer petition. She is for the respondent.
She's for the respondent. 5.
None appears on call 47. None appears on call for the petitioner. Hard MSc because the none appearing on behalf of state respondent. And also hard your miss
Nikita Kumari.
Nikita Kumari, also hard MSc Nikita Kumari appearing on behalf of respondent. For number 2. Please see matter accordingly. After 2 weeks. After 2 weeks. Yes.
My lord, in this case, we filed a petition for adding the informant as respondent number 2. That petition has been allowed. We accordingly, my lord, has taken steps. Whether a notice is to be issued. Question. To the respondent number 2.
Notice will have to be issued, Lord. Because they have added the respondent number 2.
I can you tell us the number of I?
Number of 809.
809. 809.
Other document.
This I was disposed of, but there's no separate order in the criminal revision petition itself.
It is yes, that is why. Order is to be passed. Issued a notice upon the
Heard Mr. J. Ahmed, Tilani counsel for the petition, and also heard Mr. K.P. of Tilani petition appearing on behalf of the state respondent. It is seen that by order dated 5/9/2024, passed in IA criminal 809 of 2024. The prayer for the prayer of the appellant to array the array 1 Rajiv Bedi, took the party of the appellant to array 1 Mr. Rajiv Bedi as respondent number 2 has already been found. Full stop. In terms of this, the petitioner is thereby asked to take steps on respondent number 2 to register age and ethnic process. Please see matter accordingly after 4 weeks.
I already have taken a step. It was
Steps is already
already submitted.
Office note is not there.
But
Steps is already there.
already we submitted.
Already you have submitted. However, it is submitted by Mr. Ahmed that the in pursuant to order passed in I criminal, they have already
Submitted on form.
submitted the state for the raised. Okay, raised will be.
My lord, I am very sorry, my lord. Code number putting in one item 24. I could not be, actually I see the notification later on. Item 24, I think it is.
In which item you're saying?
Item 24, foot number 14.
Item 24 of
Foot number 14. I am sorry, my lord, I could not come back.
It just kept pending.
So we can understand the problem with all the advocates and
So, my lord,
I think.
problem is, my lord, in this case, leave has been granted.
Court number.
Delay condone leave has been granted, my lord.
Informant তো মানুহ আহিল
আচ্ছা শুরু করেছে
তো করছে আর এম মজুমদার আপনারা তো এলসিএ ফোন করো
There was a delay, it was condoned, then leave petition has been allowed. It is a petition for appeal for file against acquittalment.
Leave petition was already
Already allowed. Last week. So, 32, my lord. I had 32.
So thereafter it is numbered.
So it may be admitted, and already opposite but already appeared.
opposite party appeared so LCM may be
They-
called for admitted and LCM
Admit LCR may be called for.
Opposite party has already
Already
appeared
they are no more
R
certification.
Mojumdar, R Dhar and BC
Now they already appear in the IA also. In the IA also they appear. I always have the copy also. That.
Submitted by Mr. Ahmed and the leave petition has already been allowed and the respondent the counsel for it has already appeared at the to which no objection is raised by the plan election meeting. Happy the ethics court call for the step. It's according to the record.
High level.
Next the lawsuit.
49. Yes.
This is a delay petition, the lawsuit. There is
Delay convocation.
delay
that's 63 days.
63 days
No,
left.
263.
263 days
And he is behind the bar from last 1.5 years. Lawsuit.
reason
Reason,
reason delay
reason of delay is actually he is only the sole earner of this family lordship, and other family they are totally illiterate. So some of them have collected the money and approved this before this honorable court lordship.
under section
Section 8 of the POSCO.
oh,
Earlier it was registered as section 4.
So where are you now? You are inside, outside?
I'm inside the jail, your lordship, from last 1.5 years. Almost half of his sentence.
So you are saying that you were inside the jail, so what was the reason of delay?
Delay, Lordship, actually he is the sole owner of it due to financial.
Sole owner to he is
Yes,
inside.
yes, he is inside.
Ah.
Other family members, he has old mother, Your Lordship, and
This appeal was not referred from the jail.
not jail.
Where you have written your reasons for delay?
I've been to go disturbing. What is the paragraph?
Oh, in para 4.
I want. So Mr. Esroy,
That's right.
Mr. Esroy is an counsel for the petition. Stress appellant and also heard MSK below the United States on behalf of state response. And this is an application under Section 5 of the Limitation Act for honorary connected appeal against honorary delay of 263 days in preferring the connected appeal. File preferred against the judgmental order dated 30/05/2023 passed by learned special judge Boxo, Karbiang in Boxo case number 6 of 2023, convicting the accused appellant under section 8 of the Boxo Act and sentencing the accused appellant to suffer RI for 4 years, along with a fine of rupees 10,000 in default SI for 2 months. It is submitted by Mr. Roy that the accused belonged to a very poor family and his wife is of tender age.
Yes.
Huh?
Yes, sir.
What is the age of his wife?
20.
Or you have also married a young,
20,
minor girl.
28.
So you got married with her in which year?
That is actually I'm not.
Petitioner is our India.
He is a legal from tender age. That's okay.
Remember,
31 pro.
31. And wife is 28.
28.
So you are supposed to be convicted in fact.
Why?
Otherwise, you have made a POXO attempt that is already out there. And that apart, you got married with a minor girl.
No, minor 28.
20 years now, though.
20. It's not 28.
28.
28.
28. A lady of a 28 years wife. You're saying that being a tender age can be considered as a tender age.
Oh, sorry.
Huh?
Sorry.
Due to financial hardship, his wife could not arrange for. His wife could not arrange for an appeal within the statutory period of limitation. But there is no negligence or laches on the part of the appellant, who is still inside jail, preferring the accused. Accordingly, it is submitted that prayed to condemn the delay of 163 days to prefer the appeal. According to the MSK become the there is no objection in that regard. But considering the ground for delay, which is considered to be reasonable, the petition be allowed. Filing number with us. Okay, your petition allowed.
Not well.
May I please the law? Now, since in attended the 45, my lord, actually I was sitting in court number 21 as if the matter will be taken by the court. I didn't notice the matter. My presence may be recorded, my lord, in this case.
45. P.
I do-
Chanda.
Lordship.
Apni have you taken?
And it is
Shabnam,
LCR is there.
LCR is there.
in which court number?
Actually, the matter was listed
21.
in
In which
21. Same.
21.
your presence will be recorded?
My lord, the matter will come up for orders on next week, 23rd, my lord.
No, no, they cannot fix.
My lord, it is an order matter, my lord.
Also, huh?
Orders matter, my
Yes, yes, orders. We have already dictation is taken by other.
Presence to deliver the.
Lordship.
No adverse order has not been passed because
Lordship,
we know
lordship.
the condition or situations. Because that's why we are calling the case numbers repeatedly for one to occasion,
Lordship.
because there may be, because arrangement is made suddenly in the morning itself.
Lordship.
So they are made.
Lordship.
We'll record your presence.
Diploma.
We'll record.
Diploma.
Here. No, 21.
21. Item 50 hearing. None.
Item 50 hearing. None appears. None appears. None appears on call. As well as the respondent side. This is matter accordingly. After 3 weeks good. Yes. After 3 weeks. Time.
May I please also? He was arrested on 14/4.
Yeah, okay. No. We can do it.
I said, very short.
This will be there. But they are not there. But they are not here. Can go. Yes, what was the matter?
Matter is NDPS, Lordship. Arrested on 14/4/24. Today is 156 days behind the bars. And next one is the FIR, Lordship, fine. Actually, from here.
You have received the CD already.
CD is there. Actually, page 7 you'll also find, and extra one is the FIR. What happened to the petitioner? He was staying in the house of one Hasem Ali Paramani.
It's a transited matter.
No, not suspected. Investigation.
So how many days you are behind the
156 days.
150.
14/4/24 he was arrested. So from he was taken to his house, and from his house 22 bottles of Escaf cough syrup was seized, Lordship. That is the only allegation against him. So far, this accused is concerned. Now you will also kindly see the seizure list. Page 13, Annexure 3.
13.
13. Total 22 numbers of Escaf cough syrup suspected to be codeine phosphate, being number so and so, batch number. Interesting thing, Lordship. Here the quantity is not given. So in order to ascertain whether it is commercial or not, quantity must be there. Only they have stated in the seizure list is 20 bottles of Escaf. So how will the commercial that thing, whether it is 1 kilo or not, how it will be ascertained? So this is one of these honorable, this High Court has passed, saying that benefit was given to the accused and he was granted bail because this quantity was not mentioned there. Only 50, in that case it was 17 bottles. In this case 22 bottles.
100 ml.
Now that you have to presume and assume. Where you have stated. That must be stated in the seizure list. This will also kindly. Somewhere it should be stated.
এটা বস্তু চাওঁ ইয়াৰ আগৰ পিছলৈ কোনোবা ডিসপোজ কৰিছে মই নাৰাখোঁ নেকি মোৰ আছে গতিকে আৰ্মেট Yes, Mr. Das.
So that is my submission regarding that.
But firstly, in his presence, these codeine bottles are found. Moreover, another person is also there in whose house this heroin were found, Lordship. He was also present at that point of time. This person, Lordship, the present petitioner. Moreover, FSL report is also there. According to it, it is affirmed that codeine is there. And Lordship, heroin also affirmed. Heroin is there. Moreover, Lordship, this person in one of the bail objection, Lordship, police has stated one thing, Lordship. This person was also registered under another case, Lordship. Lordship may kindly look into that. Thank you, Didi. Point number 3 and 5. Point number 3, look.
This petitioner, name of this petitioner
Is Anwar.
Atwar.
Lordship, Anwar
Ali Sheikh.
Anwar Ali.
Mithun. Alias Mithun.
What was the quantity of the heroin which has been also been seized?
Lordship,
That is 25.0.
25.
25.05 gram. That is not a commercial quantity. Above 250 is commercial. That is again, that was found from the possession of the other co-accused.
FSL is FSL.
FSL is there, Lordship. No, file has been there, Lordship. I have returned it, Lordship.
Court file.
And also hard discharge. He did not take construction that we do every the summit by yes. Submitted by and accounting for the petition that the present no mechanical in the LS documents. Also, the only eligible documents the present petition is that the 22 numbers of cups S cup syrup was recovered from his possession. For the so there is no specific mention in regards to quantity of protein phosphate in the say S cup syrup. He further submitted that the coordinate bench, this court has earlier passed an order dated 6/10/2021 in bill application number 215/2021, wherein also it has been considered that without any specific mention about the quantity of quantity of even if you fine, I can do earlier plus he also relied on it order by this court in bail application number 15 of 2021 dated 6/10/2021, wherein also observed that the 100 ml containing 100 ml of syrup is not sufficient to know about the potent phosphate available in the couple of the cup syrups, and from the FSL report also it is not specific as to the quantity of the potent phosphate in the syrup, in the potent phosphate in the cup syrup. Mr. Traore, according to the petition, he also he is behind the person that 156 days, considering his position also he may be released. Mr. Das submitted that the present that there is sufficient interpreting materials against the present expedition, and he is sufficient interpreting materials in the stuff more so from the FSL report also it revealed that the potent phosphate is available in the bottle of the cup syrup which was sent for examination in FSL. Apart from that, in presence of the present petitioner, 25.05 gram of heroin was also suspected heroin was also recovered from the co-accused, and as per the FSL report also it was confirmed that the powdery substance contained the heroin. Mr. Das further submitted that he is not only involved in the present case, but from the report of the IO also seen that the present accused petitioner is a veteran criminal, and he was earlier also charged with another case in connection with Godipur case number 106 of 2024, and And after his arrest, the similar kind of crime has already been decreased, as he was the main kingpin or the peddler in the entire area which he belonged. Accordingly, I also raised bail of against against next year, considering the subsequent date that on accounts of purposes and also considering the materials available in the case diary report of the FSL, it is said that the IO has already collected against the present petitioner, and apart from that, the FSL report also verifies the presence of codeine phosphate in the Escap syrup bottle, which were sealed from the possession of the present petition. From the report of the IO also, it is seen that he is also wanted in connection with other cases, and that he is a better he is a better in the entire locality. Stop. The fact that the entire 22 numbers of cup syrup were not sent for examination in the FSL, but from the report of the FSL, it is that the codeine phosphate is available in the cup syrup bottle of the cup syrup, which was already sent to the FSL. So without doing considering all these aspects of the case, I do not find it a fit to allow the accused to go on bail at 15, and accordingly the same stands. Your petition stands rejected.
At this stage, your lordship will say. Because already 156 days he is behind bars.
That is different. Oh.
In this case, my lord, I have submitted written argument, my lord, before your court. And
yes, it's already
yes,
there.
on 17/7, my lord, your lordship had this matter on length, my lord. And I have submitted a 6 rulings, my lord. And that is before your lordship in file, my lord. Is file.
Available in file?
File, my lord. It's file, my lord. And in this case, my lord, petitioner is in custody is 1 year, 11 months, 5 days.
Yes.
My submission, my lord, certain seizure was made after sunset. It was in the month of October. In the month of October, sunset at 5 p.m. The seizure was made at 6:35 p.m. The facts reflected in the FIR as well as in the seizure list. The reason shown in the FIR is not satisfactory. Section 42, subsection 1 is not complied with. And my lord, second ground is inordinate delay of trial. Charge sheet was laid on 27/12/2022. Till today, only 3 PWs examined out of 11 PWs. Well, last one was examined on 11/8/2023. That is 11 months, 15 days elapsed. No PWs examined, which aptly says that there is inordinate delay of trial. And number third ground, my lord, seizure witnesses have not supported the case. 2 seizure witnesses, namely PW1 and PW2, were examined. PW1, who is the BDB secretary, has connection with police. Both deposed that 2 accused persons were standing outside the vehicle. Nobody seen the accused possessed with a contraband. Mainly, we are seeking bail on 3 grounds. And my lord, that 6 numbers of citations I have referred, my lord, it was for your lordship. In Bhutta Singh versus State of Haryana, passed on 16/4/2021, it was a non-compliance of Section 42 of NDPS Act. Sarija Banu A. Janaratani alias Janai versus State through Inspector of Police 26/2/2004, non-compliance of Section 42 of NDPS Act. Nitish Adhikari alias Papon, Muhammad Salman Hanif Sheikh, Rabi Sheikh, and Muhammad Muslim. These 4 are inordinate delay of trial.
You are here. I have with me here Mohammed Muslim is here,
Yes, Mohammed Muslim.
and Mohammed Salman Hanif.
Yes. Ravi Prakash.
Then you have Sarija Banu
Yes, my lord.
and Asif.
Yes, ma'am.
Yes, I have.
And another, my lord, Nitish Adhikari.
Nitish.
My lord, I will submit it, my lord. Nitish Adhikari, LS
You are
Papan.
going to submit now.
I'll submit. Well, I will collect it and submit it now.
Yes, Butch.
Yes, my lord, here this FIR dated 11/10/2022. my lord. Here and the charge sheet dated 27/12/2022. It is the came before the learned trial court on 4/1/2023, and the charges accordingly framed on
CS on.
CS on, my lord, that is 27/12/2022. 27/12/2022. My lord, here the
Charles Benframe.
my lord,
Charles Benframe.
charges were framed on, my lord, 3/6/2023. My lord, till today, 3 numbers of PWs were examined. Total 11 numbers of PWs are there.
This is for till when it is updated. The
Up to date, my lord, it is up to date up to that is 23/7/2024, and next date is fixed for evidence on 19/9/2024. This month, my lord.
this is updated till when?
23/7/2024, my lord. This is the last date.
Acha, and next date is
The next date fixed for evidence is 19/9/2024, my lord.
My lord,
This month, my lord. Now, my lord, before going to this, the pedo trial part, my lord, my learned friend has submitted that because the section 42 is not complied with during the seizure. My lord, here in this matter, the section 42 will not come into play. The section 43, because it is in the public place, and during the Naka seeking from the vehicle, that was recovered, and the person, that is the present petitioner, he is in the conscious possession of the death. Is Islamuddin. Along with him, another person is also there. Now, my lord, therefore, that is the 42 will not comply. Here it is the section 43, and it is a public place. In the case of Nawaz Khan also, it is very clear. As because that is the paucity of time, they are not able to take the authority letter under section 41 from the gazetted officer, and that is being mentioned in the GD entry, and the reason is also mentioned there. Now, my lord, the first evidence that is on up to PW3 that is examined, my lord, and after the examination of the PW3, the next date was 8/9/2023, my lord. Then 6/10/2023. On both the occasions, my lord, the PWs were absent. On both the occasions, 8/9/2023 and 6/10/2023. Both the occasions, PWs were absent. Then, my lord, the third date is 21/12/2023. One PW present but could not be examined because defense prayed for adjournment, my lord, on that day. That is the 21/12/2023. Thereafter, my lord, the next date was 21/2/2024. Summon issued to PWs not returned, my lord, that day. And because of that, my lord, nobody was examined. 21/2/2024. Then, my lord, 12/4/2024, PWs absent, my lord. And 6/6/2024, one PW present but could not be examined, my lord. So that is the order dated 6/6/2024. And, my lord, then thereafter 23/7/2024, that day PW was absent, and next date is fixed on 19/9/2024. Now, my lord, 3 numbers of PWs were examined, and PW1 and PW2, they were the seizure witness, my lord. And from the statement of the PW1, PW2 is very much clear, my lord. That is his involvement is there. They are able to recognize the person. Even there is one statement regarding the other accused person, but regarding this petitioner, he is they are able to recognize him, his presence in the place of occurrence. My lords, in this stage, 11 numbers of witnesses are there. 3 numbers of witnesses are already being examined. And my lord, at this stage, my lord, my humble prayer is that because my lord, contraband is that is recovered from the conscious possession, the car itself, and the statement which is made by the petitioner in the this petition itself. I think my lord, para 6, that it is statement is that he is known to the another person who says that he is the driver of the. So my lord, not at this point, but admittedly, my lord, there must not be delay in the part of the prosecution, and the trial should be good. My lord, my humble prayer before your lordship is that may not be granted at this stage because they are recognized and the trial is going on. And one occasion defense has prayed for there is the adjournment, and another one occasion the PW is present. That is not could not be examined because of some reasons. My lord, maybe may not be pleased to grant this prayer, and maybe there may be a direction for the speedy trial, speedy disposal of this. My humble submission for your lord.
My lord, the last PW is examined on 11/8/2023, and today, my lord, it is 16/9/2024. 1 year, 1 month. And my lord, this 42-1, my lord, that it is, I have submitted a Bhutasing judgment. It is a private vehicle, authorization letter was required, whatever may be. So my lord, in this case, and all the Caesar witnesses saying that they did not see the person within the vehicle. They are seeing that outside the vehicle. So possession is under cloud. The 42-1 is under cloud. And inordinate delay is a fact, my lord. It is a fact. And 11/8/2022, 1 year, 1 month, and in the number of occasions, my lord, our High Court passed judgment. In Muslim, in Muhammad Muslim case also, Nitish Adhikari, in Shariful Islam, in all the cases, my lord, Honorable Supreme Court said that inordinate delay of trial is the ground of bail. My lord, I am seeking bail on this count. I will refer 3 more judgment, my lord.
Obliged. Obliged.
May I have their lordship? My lord, this petition is filed against the lordship. My lord, against the NBW issued against the lordship petitioner lordship. Now lordship, fact of the case is that lordship, and lordship, notice was issued lordship already. Notice issued lordship for the private listener. Now lordship, I have relied on order of this honorable court lordship. Similar case lordship.
It comes in the order column, my lord.
Order column lordship.
I'm not going to hear the matter.
Lordship.
As per your notices, sir.
Lordship. Lordship, as per my information, lordship, duty is served, lordship. Lordship. And lordship, in this regard, lordship, I placed one judgment, order lordship of this honorable court. Lordship.
My lord, that is summoned, my lord. My lord, today I don't have the copy also.
We don't have also.
Police.
We on the last occasion that is on the order the board of Feb 9. It's received back her daughter received the argument. Anyway, it is
My lord.
served again.
My
Yes. Criminal petition. POSCO is there, lordship. And lordship, if lordship going to the FIR, lordship.
No, we are not going to get
Lordship.
He's not in a position to hear it. Argue it.
Lordship.
It is other arrangement. Not in
Lordship.
we dispose of, we are disposing.
Actually, Lordship,
Abdul Haq was the informant.
informant.
In
In the POXO case, this is for quashing.
Not for watching Lordship. NVW Lordship. On the first stage Lordship, NVW issued Lordship. And in this regard, Lordship, our Honorable High Court Lordship, Lordship.
From the office note dated 12/9/2024, seeing that it's a notice on the response number two, which is written by his daughter, her signature. However, no one has replied respondent number two. Linked to the matters. You want any fix it?
Lordship, on Friday Lordship, because of Lordship,
It's a court of others. I don't Friday.
actually Lordship, petitioner was showing abscondal Lordship. A petitioner is ready to face the trial Lordship. Lordship, obliged Lordship. Both the cases Lordship.
My lord, 3 years. My lord will kindly take up the IA 730.
We are not in a position to take up it. They are not in a
My lord,
no, it's okay. Arrangement is that suddenly in the morning hour. So
my lord, the client is, my lord, at the end of the day, the litigant is inside the.
what is there? We are not on that. Because it is the case, yes, for sure. What do you want to say?
My lord,
My lord, may I just say one line?
Yes, but
My lord, LCR is also received, my lord, but I am not in a position to go through the same. my lord.
আর্গুমেন্ট কৰিবলৈ নাই এইটো আর্গুমেন্ট এইটো সাসপেনশন অফ সেন্টেন্স তার ক্ষমা বাকি আছে
My lord, I am not. My lord, that is precisely why, my lord, I'll just say one line probably, your lord. My lord, 3 years, 6 months is the total conviction given under intermediate quantity. 3 years, 6 months. This man is behind the bar for 2 years. I am only on the IA, suspension of sentence. I am not on the appeal side, my lord. Only, I'm.
number 18 is there, no?
এইটো কেলে আনি দিছে এইটো কেলে দি দিলে
But the suspension
is Friday.
Friday.
Friday will do.
will do, my lord. Otherwise, also, my lord, suspension of sentence probably, my lord, will not go into the LCR also, nothing, my lord. Because it is just for suspension of sentence, the IA is one liner IA, my lord. 2 years he's already spent. 1 year and 6 months, my lord, again getting it listed on Friday. Because I'm not going to argue on the PW1 and PW2. It is only on the simple fact that, my lord, 3 years, 6 months total conviction. 3 years, 6 months. 2 years he has already spent.
Up 29.
No, sir. Sir, okay, fine. Report আহিছে. Supreme Court has subjected My lord, that was received just a few minutes ago. OC concerned has sent me through WhatsApp the message I forwarded to. CS is submitted, my lord, as per the report in this matter. ৱাইফৰ নামত আছিল নেকি সেই মানুহজনৰ মঞ্জুৰ আলী
Against which order?
Lordship, at page 22, annexure 3, order dated 21st 6/24. Lordship should place before the learned court below for releasing the freeze money.
Order was what you said, or did it?
My lord, page number 22
22,
of the
Lordship.
petition. 22, my lord. 22 of the petition, my lord. Order dated 21/6/2024. My lord, here from the order, it is reflected from the fourth para, my lord. That from the order, it is the fourth paragraph of this order, my lord. It is stated that produce the report of the IO, wherein the IO submitted that the owner of the freeze money, account number so and so, is of the accused person's wife, as per the statement of the accused person, Majnoor, and the freeze money is not required for further investigation. But the freeze money cannot be handed over to the petitioner as the source of depositing of money is yet to be found. That line was there, my lord.
This petition, your Mahika Khatun, she is not been accused.
No, Lordship.
She is not accused.
She is the wife
Not
of
been
a.
accused.
Yes,
Wife of the.
yes, Lordship.
But okay, then it's okay. Your charges has already been filed.
Lordship.
And from the report of the IO that your
Yes.
already they had requested the bank authority to answer it.
Lordship.
So your purpose of filing is already been
Yes.
Met Lordship.
purpose because already
Lordship. Lordship.
Yes.
okay, because all the order is there.
Lordship.
And here also one thing, therefore the interest of the investigation, the efforts that number so and so, was not required for the partner. SBI authority is intimated to ask it
Lordship.
with already.
Yes, my lord. 39/2024 letter.
Yes.
Account number to
Later
pay.
of 13, but later of, oh, nine,
This month, my lord. This month. And the report, status report this to date, my lord. 16/9. 16.
Last to 9345.
934 409 50934.
SA Riyaz Lordship.
Additional bank account. SBI bank account 09885045. That will be already 2024. Past learned additional company metro arising out of Jalapur PSCS number 25 of 2024 under section 120B, 328, 379, 420, 406, IPC, was taken and the prayer for releasing the freeze account was same. Had ordered 3/9/2024 this court after investigating officer to apprise the court in the up-to-date status of the case of the January 25 of 2024 and also inform it to freeze count of the presentation. Mr. Bose accordingly submitted that the IOF has already submitted status report of the case as well as the status of the freeze account of the appraisal of the life that delivery case number
25 of 25 of
25 of the 24 has already been charged against one Manjur Ali alias Gadia. Gadia and that we have already intimated the bank authority to unfreeze of present petitioner invite a separate letter to the address relating to the branch manager on 13/9/2024. Sale account. In view of above, the present petition has become has already account of the petitioner has is to unfreeze by the investigating authority. Accordingly, the petitioner will be in a position to operate her account with view of so and so is said. Copy order
Lordship.
apply for the
Lordship.
They have communicated with you.
Yes, Lordship. Deeply obliged.
My lord.